The chair recognizes the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman. I thank the witnesses for your testimony. This has been among the most interesting that I've been seated here in my more than a decade on this committee. As I listen, I'm listening to Mr. Lazarus, and often your dialogue goes to the policy effect of this rather than being tied to the constitutional language or the statutory language, although you've referenced both. And I'm curious as to what you think the limited powers of the President might be, given you grant him such latitude to amend Obamacare, extend the statutory deadline because it conforms with the broader intent of the law, and your reference to the intent of Congress that they really intended to allow for the application of taxes and the distribution of refundable tax credits, even though Mr. Cannon testifies that that's not in the section that applies. So from a broader perspective, could you tell me how you think the President's powers are limited? And I maybe just ask, does he have the power to lay and collect taxes?
Well, first of all, I think that the President's powers are limited by what the statute provides. And I think I've said several times, I agree entirely that the President cannot simply refuse to apply or enforce a law for policy reasons.
But can he regulate commerce, for example?
The President is obligated to phase in a new law.
I'm sorry, Mr. Lay, I hear that, but I'm trying to get to the constitutional limitations that you think the President has. Let me just bypass the enumerated powers with the exception of, what would happen? And I'm concerned about Mr. Turley's statement that we get into a pretty dangerous area here if we don't have constitutional limitations. What if we just leap to the end of this thing? What if the President declared war? What if he assumed that authority? What is the recourse then? What would your counsel be to this Congress if we objected to such a thing? Or even if we objected to it on purely constitutional grounds and we thought it was a good policy decision and he vetoed our resolution to declare war? That should get us to the bottom of this discussion.
Well, the President doesn't have the authority under the Constitution to
Correct.
declare war. The Congress does. The Congress has not been enormously eager to exercise that authority in my lifetime. But that's a very complicated subject, and it's the subject of
thank you, Mr. Lazarus.
Interplay between Congress and the executive branch. There is a War Powers Act. There are disputes about how.
Let me then pick it up from there. That I'm illustrating this point that if there's an incremental march down through as a President overreaching his constitutional authority, in my opinion, I think the opinion of many people on this committee in this room, he could assume among that any of the enumerated powers and the recourse that Congress would have, all the way down to the declaration of war, and the recourse that Congress would have would be pass a resolution of disapproval, or we could shut off the funding through the power of the purse. And the President's already assumed the power of the purse, and so the next recourse is go to the courts, and if we find out that the courts do not grant standing for members of Congress, then the next recourse is, I think as Mr. Rosencrantz said, the word that we don't like to say in this committee, and I'm not about to utter here in this particular hearing, the balance I want to come to is ask Mr. Cannon this question. The frustration of this balance of powers because of the disrespect for the various branches, the competing branches of government that come, and I'll argue that the Founding Fathers envisioned that each branch of government would jealously protect its constitutional power and authority, and that static balance that would be there would be the definition of a brighter line between the three articles of the Constitution. But what's your suggestion on what then finally resolves this? I know we said elections. If the elections are affected by decisions of the executive branch, what do the people do who are the final arbiters of this definition of the Constitution if they're even frustrated by the election?
Is this to me or
I'm asking Mr. Cannon, please.
I think it was to me. And you're asking if there's no judicial remedy and there's no electoral remedy, what do the people do? To what particular sort of abuses are you?
Any one of the list of the enumerated powers, for example, ending with the declaration of war, because that's the starkest of all.
There is a procedure in the Constitution that it allows the people to amend the Constitution without going through Congress. That is another method where the people can try to restrain the executive.
Let me suggest then, if that should happen, why would an executive with such disrespect for the Constitution today honor an amended Constitution from a constitutional convention?
That is an excellent question.
I think I'd like to turn to Mr. Turley and ask him if he's had a chance to reflect upon that earlier statement of the situation that we are in and where this goes. We need to look into this future, and I'd ask that unanimous consent for that additional minute to ask each of the witnesses to tell us what's America look like in the next 25 years if we have executive upon executive that builds upon this continual stretching or disregard of the constitutional restraints and the disrespect for Article 1. I start with Mr. Turley.
You may answer the question as quickly as you can.
Okay. I really have great trepidation of where we are heading because we are creating a new system here, something that is not what was designed. We have this rising fourth branch in a system that's tripartite. The center of gravity is shifting, and that makes it unstable. And within that system, you have the rise of an Uber presidency. There could be no greater danger for individual liberty. And I really think that the framers would be horrified by that shift, because everything they dedicated themselves to was creating this orbital balance, and we've lost it.
As I've said before, I think the ultimate check is elections, but I don't think you should be hesitant to speak the word in this room. A check on executive lawlessness is impeachment, and if you find that the president is willfully and repeatedly violating the Constitution, if on your hypothetical he were to declare war, I would think that would be a clear case for impeachment.
Well, I guess this is the first time I've heard anyone complain about the possibility that this president is going to unilaterally declare war and be over-aggressive about that. I don't really think that's much of a description of his foreign policy. But Congress has lots of power if it chooses to use it. The power of the purse is an enormous power. I think that if I were you, I'd find ways to influence policy in using the Congress's powers, which you're not doing. I mean, for example, we're hearing complaints about the president's actions to not enforce deportation against certain classes of immigrants. Instead of complaining about that, this committee could hold a markup and report out a comprehensive immigration reform bill, send it to the floor.
Mr. Lazarus, you are, not you, but the questioner is 2.5 minutes over, so if you can dispense with giving us advice on what our legislative agenda should look like and answer the question, I'd be grateful to you.
Okay. Well, but that is an answer. I think that Congress has a lot of power and it can use it.
Okay. And I assume that the failure to exercise is also an exercise of power, the failure to act. Mr. Cannon, would you like to briefly answer?
Maybe Mr. Lazarus knows better than I do how many bombs the president has to drop without congressional authorization before that becomes war. I don't know the actual number. But I think what Mr. King was getting at is, there is one last thing to which the people can resort if the government does not respect the restraints that the Constitution places on the government. Abraham Lincoln talked about our right to alter our government, or a revolutionary right to overthrow it. And that is certainly something that no one wants to contemplate. But as I mentioned in my written and my delivered testimony, if the people come to believe that the government is no longer constrained by the laws, then they will conclude that neither are they. That is why this is a very, very dangerous sort of thing for the president to do, to wantonly ignore the laws, to try to impose obligations on people that the legislature did not approve, etc.
An excellent conclusion. Thank you, Mr. Chairman. I yield back.
The Chair would now recognize the gentleman from Pennsylvania, former United States Attorney, Ms. Marino.
Thank you, Chairman. Professor Lazarus made a statement about, at least I inferred, about this being political. I want to assure you that I left a lucrative law practice to come to Congress in 2011 because I continually see the eroding of the Constitution. I'm a constitutionalist. It's what protects us. So I'm not here for the pomp and circumstance, for the notoriety, or to promote my career. I'm here because I'm concerned about the future of my children in the Constitution. So I want to make that perfectly clear. Number two, You made a comment, and again, I inferred that the intent, there was no intent wasn't an issue or was an issue in part of the Affordable Care Act. And I don't want to get into the details of that, but I find that interesting that you made intent the issue when the Speaker of the House at that time, Nancy Pelosi, said we have to pass it before we know what's in it. Okay? So, let's get real about this. Now we're finding what is in it or what is not in it, and I'm hearing consistently from my constituents, small businesses, how this is destroying them. Let me be the first to say that I think everyone needs health care. And those that cannot afford it, we that can afford it, have to help those individuals. I firmly and truly believe that. And so with that, I would like to read you something. I'm not a constitutional expert, but I loved constitutional law. I follow constitutional law ad nauseum. Just ask my wife. I'm always talking about constitutional law. But in Federalist Papers 51, it said, what is government itself but the greatest of all reflections on human nature? And it went back to refer to, but the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others. And the government was set up to specifically prevent that. And the problem is, I am seeing here, not only in this administration, but in the previous administration and several administrations, the executive branches taking for granted that they have exclusive power over issues that they don't. And I'm concerned about that. And what do we do to prevent that? But where does it stop? And here's my question. We've seen the president and past presidents concerning the War Powers Act, which I think have violated the Constitution. But in this administration, stopped enforcement of detaining illegal immigrants, stopped enforcement of drug laws. I know that because I'm a prosecutor. I saw it. Stopped enforcement of mandatory sentencing, stopped parts of Obamacare, the Benghazi issue, the AG being held in contempt, the IRS issue. How many more things do you think have to occur? And I'm thinking like a prosecutor. One of those in and of itself is not enough evidence. Two of those in and of itself is not enough evidence. But the violations that I see here that I just listed, and there are many more, I think is enough evidence to start asking questions. Where do you see the line drawn in what I've recited here as enough evidence to start asking questions about presidents exceeding their power?
Well, first of all, Congressman, I can't address all of the
and I don't
many
expect
things
you
that you've raised, but many of those things, let's be honest about it, are honest disagreements about policy or about how to interpret the law. And
so your interpretation of the law is, you're saying you don't agree with the way perhaps I'm interpreting the law, so you say I'm wrong.
No, just to finish the sentence, raising the specter of some kind of grotesque presidential assertion of unwarranted authority here, it's just not based on fact. Mr. Cannon, for example, strongly believes that his interpretation of the law, which would sink Obamacare in his view, is correct, or I guess he does. The president disagrees with that. The president has very good reason to disagree with that. So to say that he's not taking care that the law faithfully...
Okay, let me reclaim my time here. But when laws are enacted, they should be followed to the letter. And it's not being done here. And I've heard you raise the issue of, well, prior administrations have done it. To me, that's no excuse not to pursue this from a congressional standpoint. Because whether it's Obamacare, whether it's War Powers Act, whether it's going into Iraq, these are all issues that I'm deeply concerned about. So you've criticized and you've you've made some, I think, remarks concerning that I don't think you take some of this seriously of what your colleagues have to say up there. So give me an answer as to what you think we need to do to get to curtail the executive power the way I think it's been abused over the years.
You may answer the question quickly.
Well, I think you can pass legislation to overturn an executive action you disapprove of. You can withhold funds for it.
Well, let me ask you, show something right there that you're not reciting either. 94% of Obamacare is mandatory spending. And the Democrats passed that unanimously without any votes from the Republicans. So it's mandatory spending. Nothing can be done about that at this point. It's the law. And I yield back my time. Thank you.
Thank the gentleman from Pennsylvania. The chair will now recognize the gentleman from New York, my friend Mr. Jeffries.
Thank the distinguished chair as well as the distinguished ranking member for his leadership and the panelists for their participation this morning. If I could just start with Professor Rosenkranz, and I want to explore this issue of prosecutorial executive branch discretion, particularly in the context of the enforcement of our nation's immigration laws. But if I could just start with some foundational questions. The Department of Justice, for example, is an executive branch agency, correct?
Yes.
And federal prosecutors within the Department of Justice are exercising executive branch action in the context of their participation in the criminal justice system, correct?
Are exercising executive authority, yes.
Executive authority. Mm-hmm. Now, when prosecutors make a decision to, after initially charging someone with a serious offense and then agree to a plea bargain to a lesser included offense, short of what they may have concluded the evidence provides that particular defendant was guilty of, is that an appropriate exercise of prosecutorial discretion within the four corners of the Constitution?
Well, I guess it depends on the circumstances of your hypothetical. It would not be appropriate if it were, for example, motivated by race or something, but on the facts you've described, if the prosecutor thought he didn't have the resources to prosecute a particular crime or perhaps wasn't sure that he had the evidence for a particular element of the crime, then yes, that's an appropriate exercise of discretion.
And the executive branch, and in the prosecutorial context, for instance, the Department of Justice, or in the immigration context within Homeland Security, they have an ability to prioritize the nature of the offenses that they enforce. Is that correct, as an appropriate exercise of their constitutional authority?
The executive branch has authority to husband its resources in the most efficient way that it sees fit. So the president doesn't have the money or resources to completely execute every law, and so he does have to, by necessity, make decisions about enforcement priorities, yes.
Now, so you've concluded, I believe, that the presidential exercise of authority in the DACA context with respect to deferred action, certain class of individuals, do you believe that that's an unconstitutional exercise of his authority?
Sorry, in the immigration context?
In the immigration context.
Yes, I do.
And you believe that's the case because of the fact that you contend it was a wide-ranging exercise that was not made on a case-by-case basis? Or what is the foundation of your belief that it's unconstitutional?
I think there are two basic reasons. One is that it goes dramatically further than the hypotheticals we were discussing before. This is not a prosecutor deciding on a case. This is a president deciding on 1.8 million cases. And the second striking thing about it is the president deciding on exactly the set of cases that Congress considered exempting and decided not to exempt. That's what's particularly shocking about it.
So now you're familiar with, reclaiming my time, you're familiar with the criteria that has been set forth for the determinations that are made, I believe, on a case-by-case basis as it relates to who qualifies for this deferred action, are you not?
Yes.
Okay, and so for instance, one of the criteria, you must have entered the United States before their 16th birthday and be younger than 31. as of June 15, 2012. That's one particular criteria. Another is cannot have convictions for any felony offense, significant misdemeanor, or have committed any 3 misdemeanor offenses. Those are pretty specific enumerated categories. But another category which helps to determine whether discretion is appropriate is you cannot pose a threat to public safety or national security. Isn't that a pretty broad category within which discretion can be exercised on a case-by-case basis as to whether, in fact, you pose a threat to public safety or national security, that is not a specifically constrained factor that people either automatically fall within or automatically fall without?
Well, I think it's quite a dramatic shift in the status quo. So 1.8 million people will presumptively be allowed to stay. I can't imagine but a tiny fraction of them will be found to fall within that exception.
Okay, and I would just note that of these individuals, more than 450,000 have been granted deferred action, but in excess of 100,000 have been denied access or who have not received that grant of discretion, and I yield back.
Thank the gentleman from New York. The chair will now recognize himself for 5 minutes of questions. It strikes me that the law can require action or forbid action. The law can forbid the possession of child pornography. The law can, in some instances, require you to file an income tax return. Mr. Lazarus, is the chief executive constitutionally capable of ignoring both categories of law?
Well, as I said several times, Congressman Gowdy, the president cannot refuse to apply or enforce a law for policy reasons.
Well, let's analyze that for a second. Congress decided in its collective wisdom that if you possess X amount of a controlled substance, you are going to get X amount of time in prison. You may like mandatory minimums, you may not like them. This administration summarily dispensed with that law. So my question to you, again, is can the chief executive fail to enforce categories of law that are both permissive and mandatory?
Well, it is well established that the executive branch has prosecutorial discretion to decline enforcement.
And what are the limits of that prosecutorial discretion?
You know, very frankly, I'm not an expert on that.
Well, let me ask you this. Can the president, let's assume that a statute required you to show 2 pieces of identification to purchase a firearm. Can the chief executive knock that down to 1?
I guess I'd have to know a little bit more, but I would...
It's a very simple fact pattern. You have to show 2 forms of ID to possess or purchase a firearm. Can the chief executive, under his pardon authority or his prosecutorial discretion authority, knock that down to just 1 form of identification?
Well, I'm not aware of limits on the president's pardon authority.
So you would say he could?
Under the pardon authority, the president can pardon just about anyone, not that he should. No.
Even before the act is committed?
That's the reason for...
Can he do it before the act is committed? That's my question.
I'm sorry?
Can he do it before the act is committed?
Again, that's above my pay grade. I don't really know that.
If the president can fail to enforce immigration laws, can the president likewise fail to enforce election laws?
Whether the president can pardon someone before a prosecution is initiated or before an act?
Well, I think I know the answer to that question. My question was before the act was committed. He certainly can before the prosecution. My question is this: if you can dispense with immigration laws or marijuana laws or mandatory minimums, can you also dispense with election laws?
Again, I think we've gone over this ground many times.
Well, just humor me. Let's do it one more time. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory minimums. What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws.
Did
My view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish, did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term.
Well, if you can put them in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not, this is kind of fruitless because it's an area that I really don't know.
Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say, we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
Well, my time is up, but I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
With that, we would recognize the gentlelady from Texas, Ms. Jackson Lee.
Let me thank the majority and the minority, Mr. Conyers, for holding this hearing. Let me thank the witnesses. Whenever witnesses come before our body, it is, of course, valuable, and we trust your judgment, although we may disagree with you vigorously. Let me say that the wasteland that Mr. Lazarus spoke of, and Mr. Lazarus, please let me cite you and indicate that I will be using this across the land, the vast lands of this nation, which is a rhetorical make-waste that this hearing equates, but also to suggest that the reason why this body that Professor Turley has suggested may be on the verge of some basis of irrelevancy, which I take issue with, is because under the present House leadership, we've passed no legislation for the president to be able to implement in the first place. We have not passed immigration reform. We have not dealt with the question of mandatory minimums. We've not dealt with a budget process. We've not dealt with sequester. If we would simply do our job, the relevance to the American people would exceed our expectation. I just came from the Fast for Families. Just a few hours ago, we had in this room dreamers. As far as I'm concerned, the duty of the president is to be the ultimate giver of relief within the context of the Constitution and the necessary relief of the people who are begging for relief. If you read the lines that we are so intellectually gifted to interpret, along with precedents, it says that he shall take care that the laws be faithfully executed and shall commission all of the officers of the United States. Well, I could be a believer, and therefore my faith says that the president is taking, within the context of the laws, the ability to implement to help the most vulnerable. And what we're doing here is a rhetorical wasteland of ignoring the pain of our nation. And let me give you an example. First of all, my good friend from South Carolina knows full well, as a federal prosecutor, that each day prosecutors are making distinctive decisions about who to prosecute and how, within the context of the law. And to answer the question for you, Mr. Lazarus, the issue is that in the election laws, you follow the law, but you have the right in a prosecutorial posture to determine whether you are prosecuting or not. That is what happened with mandatory minimums. That is what's happening with the issue of drugs. That is what the Attorney General is speaking of. He is not throwing laws to the wasteland. We are in this hearing, for it has no sense to it. And then it is interesting that we have not understood the question of the Secretary of Homeland Security. She issued a memo to her staff. She has an inherent authority to deal with policy. Each of the deferred adjudications or the deferments for dreamers is individually assessed. What is this constitutional gobbledygook talking about? They don't understand the difference between policy and the ability to do that. And so I have had dreamers come to my office. I could not wave a magic wand. They had to go through the process. The memo indicates that it went to CBP, ICE, Immigration Enforcement, and others. And so I'm taken aback that this issue does not come with humanitarianism, and that if there should be a hearing, it should be a hearing of the failure of this Congress to act on its constitutional responsibilities. Let me ask you on the Affordable Care Act, which is now just another way, if I might say so, of having the 50th and the 52nd and the 53rd challenge on the Affordable Care Act. Mr. Lazarus, to go back to a comment about these exchanges, another wasteland, that if your state does not have an exchange, just on practical English, it means that you in the state cannot comply, meaning you, the citizen, are left in a wasteland of non-compliance. What do you get on? And so we have established the national exchanges. Would we have preferred to have state exchanges and to have a list of state insurers? Yes. Would we prefer for Republicans not to encourage young people not to do what is best for them by getting covered? Yes. But my question is, if the directive is to run such exchanges, that means the same characteristic, federal exchange, including the tax credit that allows poor people to have insurance. Obviously, these are allowed. I'm sort of coming in the middle of my question, Mr. Lazarus. This is for you. In essence, in states that have refused exchanges, the federal government stands in the shoes of the states. Doesn't that further illustrate why you, not Mr. Cannon, are correct based on the pure text of the law, and that the president is carefully, faithfully implementing the law? Would you go over that for us again so that it can be in the record?
Well, that interpretation is what I support, what the President and the administration supports, and what I think will certainly prevail in court, and that is that what the law provides is that if a state declines to set up an exchange, then the federal government shall establish such exchange. It says such exchange in the law. And as you just stated, in common sense terms, the federal government then will stand in the shoes of the state in operating that exchange, and the exchange will be exactly the same, have all the same powers, authorities, and responsibilities that an exchange that's being managed by a state government would have. Any other interpretation, the one that my friend Mr. Cannon here is promoting so vigorously, makes no sense and would actually cause the whole exchange part of the ACA to fail in every one of these states. So it makes no sense whatsoever, I think.
May I just have an additional 30 seconds? He didn't answer. Does this not exceed, and I ask unanimous?
Yes, I'm sorry.
Does that not exceed the authority of the President?
We're already 2 minutes over, so if you
very
could
kind, Mr.
give us a
Chairman.
very pithy response.
Thank you, Mr.
Great.
Chairman. Mr. Lazarus, if you could.
I think the President is not violating his take care responsibilities by acting on the interpretation.
And do you associate with my interpretation of statements I made previously?
Yes, Mr. Chairman.
May I ask for a submission into the record? I'm finished. Thank
You can submit all your questions from the record.
No. May I just submit a document of an
Without
op-ed?
objection.
Op-ed dated August 15, 2007 by myself on signing statements. I ask unanimous consent.
Without objection. Before I recognize the gentleman
I thank the chairman and I thank the witnesses. I yield back.
Before I recognize the gentleman from Idaho, for those of our panelists who may not be able to avail themselves of the history of this committee from 2008 to 2010, the other side controlled this committee, and not one single solitary piece of immigration reform was produced. Now, let's be fair. I've got colleagues like the gentleman from Illinois who are equally desirous of immigration reform no matter who the president is. But let's don't rewrite history. From 2008 to 2010, the Democrats controlled this committee and nothing with respect to immigration reform. So don't talk to me now about what a huge priority it is. I recognize the gentleman from Idaho.
Will the gentleman yield?
Mr. Chairman, thank you for the time. Panelists, thank you for being here. Mr. Lazarus, I've been listening to you for 2.5 hours now, and I have not heard a single time where you have told me where in the law the federal exchanges are given the authority to grant these subsidies. You talk about policy, you talk about what you think the president wants, you talk about what you think the Democrats want. Tell me in the statute, just one time, where it says that the federal exchanges are supposed to give this subsidy.
Yes, I didn't go into detail, and I don't think that my friend Mr. Cannon did either.
I think he did. He mentioned the numerous times where it gives it solely to the state exchanges.
Let me answer the question. First of all, I asked that the committee include written testimony that I gave to a subcommittee of Congressman Iss's oversight committee that goes into detail about what...
just name one. I just want one section of the law. I don't have that much time. Name one section of the law.
And secondly, I also have...
You don't know. Mr.
No, I didn't say I don't know.
Well, can you name one section of the law?
I wanted to say that I had...
One section of the law, Mr. Lazarus, where it says
I would cite two sections in particular.
Okay, thank you. That's all I'm asking.
The first section is one that Congresswoman Lee referred to, and that is where the law says that in the event that a state does not set up its own exchange, then the Secretary of Health and Human Services shall establish such exchange. And our interpretation, the administration's interpretation, is that the word such exchange should be interpreted to mean that the exchanges will operate on the same terms and have the same authority. Michael does not agree with that, but that's the interpretation. Secondly, and I think this is really quite important, when the statute defines exchange with a capital E, it puts a capital E in there, it says exchange shall be an exchange established by the state under the relevant section. And then...
I reclaim my time. I just asked you a simple question. Mr. Turley and Mr. Cannon, I think both of you, coming from different political points of views, had some of the same concerns that I had about the prior administration, about the Bush administration. In fact, I read some of your writings, Mr. Turley, before I was a member of Congress. And
bless you.
and I was very concerned about the imperial presidency. I was very concerned about having a Republican with Republicans in Congress who were not willing to be a check and a balance on a Republican president. And in fact, like Mr. Cannon stated in his testimony, I think it was you, I can't remember which one of you it was, who stated that maybe the one thing that you liked about Obama, you seem to agree with his policies, you seem to kind of like the fact that he was going to be a check on what previous presidents had done. So I'm actually really disappointed that we are here at this hearing today, and I'm surprised that my friends on the other side don't think that this is an important hearing, because they seem to bitch and whine for 8 years about what the Bush administration did, and all of a sudden they don't seem to have one single concern about what this president is doing with his authority. What do you have to say about that, Mr. Turley?
Well, I believe that this institution is facing a critical crossroads in terms of its continued relevance in this process. What this body cannot become is a debating society where it can issue rules and laws that are either complied with or not complied with by the president. I think that's where we are. And where Mr. Lazarus and I disagree, Mr. Lazarus keeps on saying, look, a president cannot ignore an express statement on policy grounds. I'm not too sure what is involved here. If you look at the individual mandate, the policy issue there was that a great number of people were upset. They felt that there was a bait and switch. That's not the same thing that we see with like the environmental statutes that Mr. Lazarus points out. That's a political issue, a policy issue, where the president said, I don't want this to happen now. And a lot of people are upset with it. That would seem to me, if that's not a policy question, I don't know what is. And by Mr. Lazarus's own definition, that would seem to be outside the authority of the president. But in terms of the institutional issue that you're raising, look around you. Is this truly the body that existed when it was formed? Does it have the same gravitational pull and authority that was given to it by its framers? You're the keepers of this authority. You took an oath to uphold it. And the framers assumed that you would have the institutional wherewithal and, frankly, ambition to defend the turf that is the legislative branch.
Mr. Cannon, it seems to me that Mr. Lazarus is arguing that the president can do anything that we refuse to act on. And I think that goes beyond what the constitutional powers that were given to the president by our founding fathers. In fact, if you follow his logic, it seems to me that if he next decides that he wants to make sure that nobody who came here illegally, who came here just to work in agriculture, for example, can be deported because there would be some humanitarian concerns about deporting these people, that he has the express authority to actually do that. I'm actually a proponent of immigration reform. I want immigration reform to be done, and I think the actions of the president have made it less likely that this body is going to act because we're not sure what he's going to enforce and what he's not going to enforce. What are your comments on that?
Well, I think that there's no bright line, as far as I know, to be drawn between enforcement discretion and legislating. I think that the president's actions with regard to the Patient Protection and Affordable Care Act, wherever you draw that line, he's on the wrong side of it. But I think that one way the best way to curtail the abuse of prosecutorial discretion is to have fewer crimes. We have a lot of crimes on our in our immigration laws that I just don't think should be there. I think our drug war creates a lot of criminals that, there are a lot of crimes on our books as a result of the drug war that should not be there. And that is why prosecutors across this country are stretched so thin, why prisons are overcrowded, and when you have a situation like that where you've got a surplus of crimes and not enough resources to prosecute all of them, then you get you put a lot more power in the hands of individual prosecutors as well as the executive branch generally to decide how these laws are going to be enforced and not enforced. I think on a macro level, that's how you try to attack this problem.
Thank you. I yield back my time.
The gentleman yields. Chair will now recognize the gentleman from Illinois, my friend, Mr. Gutierrez.
Thank you very much, Mr. Chairman. Well, once again, we're not legislating in this committee. We could be using this time to find common ground and even have a strenuous and substantive debate on important public policy matters, but instead, I think what we're doing is offering empty assurances and shaping political messages for next fall. Rather than worrying about whether the president we know, and you quote, distrust or end quote, is enforcing our laws the way you would like him to, we could be making meaningful progress towards crafting and passing laws for the betterment of the American people. I hope this goes, the President isn't a member of this committee. He doesn't sit on this committee. He doesn't have a vote in the House of Representatives. We should craft legislation and get it done. And then we should make sure that that legislation is enforced. Now, I know that some people say, well, he's not enforcing the legislation. Let me just suggest to everybody, when he got sworn in as President of the United States, secure communities was nothing in this country. There are hundreds and hundreds of agreements with county, state, and local facilities. How do you think the apparatus was created to deport 2 million people in the last 5 years? By accident? That apparatus did not exist under George Bush. It was created under his administration and implemented by this president. And that's something that I'm happy about. 287G agreements that have been made with one locality after another. We're going to sit here and say that Congresswoman Sinema, our colleague, who hired one of the Dreamers after she applied for DACA and successfully got her work permit and is now her district director, her mom is under a current order of deportation. She quit her job today as a congressional aide to go and fight for her mom. And we're saying that he's not enforcing the law? I assure you that if you are fighting this administration, as I and many others are fighting this administration each and every day, you will find this president is indeed enforcing the law. Unfortunately, he should not be limiting his prosecutorial discretion. He should be expanding his prosecutorial discretion. Now, on the substantive issue of DACA, the fact is we passed the DREAM Act in the House of Representatives in the fall of 2010. 216 to 208. But then we went to the Senate, Mr. Turley, and over there they said you need 60 votes now to get something done. We always talk about the framers. I don't remember any framer saying you need more than one vote, the majority in the Senate. But now you need 60. So they only got 55. So clearly the established will of the majority of the senators and the House of Representatives was to do what? To protect the Dreamers. That's what the president did. He took the express will of the House and in the Senate, if not for this new rule that they invented, that they've had, I think, now for 35 years, that you need the supermajority of 60 votes. If we needed that here, even my colleagues on the Republican side would have a difficult time getting legislation passed. So all I'm trying to say is, when we move the ball forward, the president looked at it, and I just want to say that I don't know about the other, but it seems like Bo Cooper, former INS General Counsel, Paul Virtue, former INS General Counsel, these are general counsels of the INS. Each of them established that the President of the United States does have prosecutorial discretion when he gets to decide who to prosecute and who not to. And that's what he did. He set children aside and said, I'm no longer going to prosecute them because they do not present an imminent threat. And guess what, Mr. Chairman? A year and a half later, 500,000 of them are walking around. And I assure you, because I know the way this place works, if you could find one and bring him up here that shows how he's caused some danger or some harm, that person would have already have come. But the fact is that they're not. They're working in congressional office. 3 of them are working in my congressional office, filling out more. Look, they're American citizens and everything but a piece of paper. And all I want to do, and I want to establish, because the chairman is absolutely correct. I'm going to say this from my point. When we were in charge in 2007 and 2008, we were worried about losing our majority because your side was beating the crap out of us. I'm sorry, maybe that word shouldn't be used here. But that's what you were doing. So if a Democrat voted for immigration reform, your side would boom, 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 and knock them out, right? And then we were in the majority in 2009, 2010, and we did nothing. I agree with you, we did nothing. But let's not repeat history. Let's not say you didn't do anything, so we're not going to do anything. No, let's do something. I want to end with this because here's what I'd like to do. I want to step outside of my Democratic Party, because I know there are men and women on your side of the aisle that want to step outside of their Republican Party and join an American party on the issue of immigration. Because I know there's common ground that we can reach. And then the president won't have to be taking these actions. Because more and more what you're going to find is people are going to say, Congressman Sinema's staffer, we shouldn't deport her mom. Mr. President, stop the deportation of that mom. So all we're going to do is, look, they're here. There are 11 million of them. Let's figure out a way how we legalize their status. And let's figure out if you want triggers, let's put the triggers in. But in the end, we're going to have to come back here. And when they become American citizens, they're all going to become American citizens. We should get over that. Because you know what's going to happen, Mr. Chairman? If we pass legislation and they all don't go to citizenship, the next day somebody's going to show up and say that Congressman Gutierrez didn't do a good enough job. Because that's the way this plays. That's the positive thing. Somebody comes and says we didn't do a good enough job. Thank you. You've been so kind and so generous. I know one thing. Eventually, we're going to have a hearing here. We're going to call you all back, and you're going to let us know how we're going to get this done. I pray that that happens. It's the right thing for America. Thank you very much.
Thank the gentleman from Illinois. The chair will now recognize the gentleman from Arizona, Mr. Frank.
Well, thank you, Mr. Chairman. Mr. Chairman, the subject of today's meeting is pretty profound, related to the rule of law. There are so many examples that some of us point to, and it's hard to name them all. So I'm just going to point to a few that this administration seems to have stepped outside the boundaries of, quote, the rule of law. Taxing political contributions, again, not in the law. Political speech disclosures for federal contractors. The deep-water drilling ban. Mr. Holder's attempt to reform criminal justice by selectively enforcing our laws. Mr. Obama's unilaterally ignoring immigration laws in many cases. Recess appointments, unconstitutional recess appointments. Fast and Furious, were unconstitutional efforts there to walk guns. Unconstitutional wiretaps by of the AP. The IRS scandal, one of the more egregious ones, as the gentleman mentioned, that it subverts the entire political process. And of course, Obamacare, which I'll touch on in a moment. But all of these are examples where this president, in the words of my friends on the left, has exercised prosecutorial discretion. That's the word. Presidential pardon powers. But I think they're more along the lines of Professor Turley said these could be considered royal prerogatives, which is, if my history is right, that's what we had that little unpleasantness with Great Britain about. So the subject here is of profound significance. And I would suggest, Mr. Chairman, that not only in the application of the law has this administration held themselves unconstrained by the Constitution or even the truth in many cases, but even in the process of getting the law. On Obamacare, this was passed in a unique situation where I see in Mr. Cannon's testimony especially, it's probably the perfect citation. I see in your testimony that you write, let me say that again, quote, President Obama's unfaithfulness to the PPACA is so wanton, it is no longer accurate to say the Patient Protection and Affordable Care Act is, quote, the law of the land. And, it's kind of ironic because some of my colleagues, about 53 of us, have signed on to the House resolution stating that we believe that Obamacare has yet to be the law of the land because it violated the origination clause of the U.S. Constitution when it was passed. And we don't talk about that a great deal, but it is significant because the origination clause, which was vital to the Constitution ever coming into existence in the first place, it was the critical negotiation that took place to allow the Constitution to exist, requires that all bills for raising revenue originate in the House. And incidentally, Mr. Cannon, your colleague Ilya Shapiro at Cato has written an excellent piece at laying out this argument, and I'm going to ask that this be placed in the record here in a moment. And also would like to ask you to address it if you have a perspective of it. But the bottom line that is at issue here is that if the U.S. Senate can take a totally unrelated piece of legislation and strike everything with the number and take legislation that they call the Senate Health Care Bill and place it in its entirety, which raises taxes to an enormous degree, if they can take any bill in the House and do that, then I would suggest to you, especially after the Supreme Court has labeled Obamacare a tax, they've officially called it a tax. And if indeed it can be done this way, then I would suggest to you that the origination clause is a dead letter. There is no more purpose for it being in the Constitution. And it's something that I hope that we'll look at a little more carefully. So if it's all right, Mr. Cannon, I'm going to address my question to you. Do you have anything that would help illuminate this in ways that the rest of us can understand?
Well, this is a provision of the Constitution that hasn't really been used or employed by the Supreme Court to knock down any revenue measures that were alleged to have originated in the Senate instead of in the House as required by the Constitution. I think that what happened with the PPACA is a more extreme example of the abuse of a more extreme violation of the origination clause than what we have seen in the past. As you say, a bill came up with a totally unrelated revenue measure, came over in the House, from the House. The Senate stripped out everything within that bill, kept only the bill number, H.R. 3590, I believe, and inserted into that the Patient Protection and Affordable Care Act, which had all sorts of revenue measures, including the individual mandate, which we didn't know then was a tax, but now we know it is a tax until the administration changes its mind again, which it continues to do. There's nothing in the bill number that's a revenue measure. That's not, all the revenue measures had been stripped out of that bill. So if the origination clause means anything, then it means that that revenue measure that the Senate passed and then the House passed and that we now call the Patient Protection and Affordable Care Act originated in the Senate, and the Senate did not have the power to originate a bill, a revenue measure like that. So, but the difficulty is, will the courts enforce that part of the Constitution? There is a difficult line to be drawn between when are you amending a revenue measure that came from the House and when are you originating a new bill? I think that reasonable people can disagree about where that line will be drawn. I don't think that reasonable people can disagree about whether the Senate's gutting of H.R. 3590 and inserting into that a totally new revenue measure is on. I don't think anyone can disagree that that is on the wrong side of that line. It remains to be seen whether the courts will uphold that part of the Constitution. If they do, then probably they would have to strike down the entire PPACA. Fortunately, there is a lawsuit that's making its way through federal courts. It's been filed by the Pacific Legal Foundation that challenges the individual mandate as under the origination clause.
Mr. Chairman, thank you. I guess when if this administration does not succeed in stacking the D.C. Circuit, we should find out whether the origination clause still means anything at all with the case that the gentleman mentions.
I thank the gentleman from Arizona. The chair will now recognize the gentleman from North Carolina, the former U.S. Attorney, Mr. Holding.
Thank you, Mr. Chairman. Professor Turley, throughout your testimony, you've alluded several times that there are instances that you believe that the President has stepped over the line. And we've talked about a number of them, but I just ask for you to recap and maybe give us our top 5 instances where you think that he has overstepped the line and breached the Constitution.
Well, thank you very much, Congressman. First of all, I do think that there's a number of provisions in the ACA where he did overstep the line. The decision on individual mandates strike me as a rather obvious policy determination from the President that he did not want to see it enforced, given the amount of public opposition that occurred and accusations of a bait and switch. Those are all political issues. This was not some Clean Air Act regulation that was stuck in the mire of regulatory disagreements as to a command and control statute. I also believe that the mandate, the employer mandate, which was also extended, constitutes a significant change in legislation. I also believe that the immigration issue is well across the line. I actually agree with the President on the decision that was made, but that doesn't matter because it was not made in a way that is allowed under our Constitution. One of the things that I would point your attention to, Congressman Holding, is that if you look at each of these questions, a couple of things jump out at you. One is they happen to occur in areas of tremendous political division, if not deadlock. That is precisely the type of issue that the framers wanted to go through the legislative process, because our process, unlike other systems that would explode into the streets of Paris and other cities, we have a type of constitutional implosion. We direct those pressures to the center of Congress, and from that we take disparate factional interests and turn them into a majoritarian compromise.
If I could get you to keep going down the list of instances where you think that he has overstepped.
The other two that really come out to me is really the issue of the $454 million in the prevention fund issue for the federal health care insurance exchange, and also the $700 billion for the state exchanges, and then finally the essentially the subsidies for congressional employees, which is less significant than those other ones. So what bothers me about those last examples is that it goes directly to the power of the purse. And we have seen over and over again courts saying, don't worry, you have the power of the purse. And this administration is now directly challenging that and saying, we can take money that was dedicated for one purpose and give it to an unspecified, unallowed, or a disallowed purpose. That challenges the very rock foundation of the Congress.
Mr. Rosencrantz, do you want to add any to this list of, I've got 4?
Well, I agree with all the items on that list. A recent D.C. Circuit opinion spoke of the Nuclear Regulatory Commission refusing to make a decision about Yucca Mountains. That's quite a striking example. That's the example where the Judge Kavanaugh quote came from. And the other example that I really want to keep returning to is the IRS targeted enforcement. So to my mind, taking care that the laws be faithfully executed, the core of that requirement is non-discriminatory enforcement.
Mr. Lazarus, do you want to add any to this? Perhaps not. Mr. Cannon, would you like to add any to this?
I'd like to ask, isn't the Nuclear Regulatory Commission...
I'm going to reclaim my time, Mr. Lazarus. Before I get to you, Mr. Cannon, I want to use my last minute with Mr. Rosencrantz. Mr. Rosencrantz, you said that in extreme instances, impeachment would be appropriate to address one of these transgressions. We use the example of declaring war without congressional authorization. Say on a scale of 1 to 10, that being a 10 as necessitating impeachment proceedings. We've reeled off 6 instances where the president has exceeded his constitutional authority. I'd add a 7th in there on the what he's doing with our drug laws and the mandatory minimums and the insistence that our prosecutors not charge all the relevant facts. Out of any of these 7, which ones rise to being the most egregious, and would any of them trigger what you would think, meaning impeachment, to be appropriate?
Well, I wouldn't want to opine on quite what the impeachment line ought to be, but I think this body should think about a pattern, if they see a pattern, and particularly if they see willful conduct. That should be that's really the most egregious thing a president can do, is willfully violate the Take Care Clause or display a pattern of disregard for a constitutional prohibition. So that's what I think the committee should keep their eye on.
Mr. Chairman, I yield back.
Thank the gentleman from North Carolina. The chair will now recognize the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. I've sat here and I've listened in the back, I've listened to both sides. The thing that just disturbs me more about this hearing, probably, Congressman King said it was one of the most interesting hearings that we've done and one of the relevant hearings. I'm not going to disagree with that, but I think for me it actually brings out one of the most disturbing hearings that we're having to have. And I think it's a progression issue here. And I'm not going to be Republican or Democrat. It's happened more in the last 15 to 20 years. I think this is a progression of executives that both Republican and Democrat have used, really in some ways push that boundary, stretch that boundary, and I think in the case of this, of the president now, has outright stepped over those boundaries. And we can have legal discussions up here all the time. The problem is from where I come from up in Northeast Georgia is people they don't get it. They look at a government, they look at an executive, they look at what's going on right now, and they just basically say, this is not the way it's supposed to work. This is not what you can go back to Schoolhouse Rock, you can go to a civics class, you can do whatever, and you can be graduated law professors, but at the same point, if you can't communicate it to the people who have to live under the situation, then there's mass problems, and I believe there's a right to have a mass problem right now. We've talked about the power of the purse. I've talked all session and ever since I got up here about I believe truly that this institution has got to matter again. It's Article 1. We've talked about Article 3 a lot, we've talked about Article 2 a lot, but it's Article 1. Congress has to matter again, and that means that we have to take seriously our role of budgeting, we have to take seriously our role of legislating, but also holding accountable when we are being bypassed. And that's a concern. And we talk about using the power of the purse. I think that's been an issue that's been well trodden today. We've talked about elections, and I think that's an issue that has been discussed. But the other issue for me that is bothersome, and you try to explain, is what can you do? I'm often asked this. You got to go up there and you just impeach him. Or you go up there, you just impeach the president. Or you go up there and you just cut funds off. You shut everything down. And it just becomes a blur. And now we have Ms. Lazarus, and I respect your right to a differing opinion than mine on most things here, to say that I believe he has stepped over and you believe he hasn't. That's where we differ. And Mr. Turley, we'll agree on some things and probably agree on others. But you made a statement that said, agree or not, it was not in the bounds of the Constitution. And I think that's interesting for us to talk about for just a moment. Because it comes back to what do we do? Besides getting our, quote, act together, if you would, as Congress, what can we do? Because standing is an issue that we're having to. So I want to ask you just this question. Where do we go to begin that process of reclaiming our Article 1, our constitutional role, so that it is a three-legged stool and not right now a 1.5?
Well, it's an excellent question. And despite my deepest concerns, I remain optimistic. I'm a Cubs and Bears fan, so I've lived most of my life with unrequited desires. But it is as serious as you suggest, and there's a good reason why people can't understand what's going on, because we are acting outside the system. We've essentially taken the Madisonian system offline, and we are in this ad hoc improvisational world of constitutional law that is very, very dangerous. Where I disagree with my friend, Mr. Rosencrantz, is I'm always leery about people who say the solution is elections. The framers didn't intend for elections to be the solutions to constitutional problems. They created a system of checks and balances to allow the system to correct itself, because there are plenty of abuses. You could have majoritarian terror that would be just promulgated and continue through elections. Also, impeachment is not a good device for regulation. It's a very difficult thing. I testified at the Clinton impeachment hearings. It's a very difficult standard, and it's certainly not there as a substitute. I think that the hearing that this body should seriously consider is to have a hearing on members standing. I've been writing about this for years. I've represented members. If we had members standing, if members could go to court and raise unconstitutional acts, much of these problems would go away, because we'd be guaranteed review. Much of what we've seen from the White House, in my view, is based on the assumption, not necessarily a bad one, that nobody will be able to call them to account.
I believe you're right in that, and I think that's what, you said you were an optimist. I am too, if you've watched some of our sports teams lately in Atlanta. But I'm an optimistic realist, and I don't get on the plane to come to Washington, D.C. I still look at this Capitol, and I still believe it matters. I still believe that we're a shining light for the world. But I'm going to spend all of my time as best I can to bring us back to a balanced checks and balance system in which Congress, Article 1 authority, is respected and honored, and we also have the system that most people in this country grew up understanding. And I think that's what this hearing ultimately is about, is the respect of the people who sent us here, and we've got to continue that. Mr. Chairman, I yield back.
Thank the gentleman from Georgia. The chair will now recognize the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. Mr. Lazarus, if Congress passes a statute that applies to whatever parameters you want, can the President enlarge the parameters of the statutory text and apply it to areas outside that the statute contemplated?
No.
Okay, because it's interesting because in
I mean, let me just qualify that. This is an abstract question. It really depends on how the statute's
I understand.
worded. I mean,
and I'll give you a chance to respond because you cite bureaucrats within the administration to justify some of the president's conduct, but you actually don't cite any quotes from the president himself justifying his conduct. And I think it was interesting with this most recent, quote, legislative fix for grandfather plans. Here's what the president said. Already people who predate the ACA can keep those plans if they haven't changed. That was already in the law. That's what's called a grandfather clause that was included in the law. Today we are going to extend that principle both to people whose plans have changed since the law took effect and to people who bought plans since the law took effect. In other words, Obamacare has a grandfather clause. Anything after the enactment of Obamacare is illegal unless it meets the statutory requirements. So what the president is saying is he's extending a grandfather clause to cover plans beyond what the statute contemplates. So you think that that's appropriate?
I think it is. I think you're making a good point. I think that it is appropriate if it is temporary.
And oh, by the way, let me just say, Congress, we passed in the House a bill that would have grandfathered into plans, and I think that we should do that.
But what I meant to say was, I think it is appropriate as a temporary measure if it is necessary to effectively.
It's directly contrary to the statute. The whole point of Obamacare was that you needed to force people into these exchanges. What about this idea? If a political environment is tough, would that be a reason to delay a law or grant a waiver to a law if you cite the political environment as your justification?
I think that would be.
Congress isn't doing what I want. I may suffer political damage, so I'm going to do it anyways.
No, clearly that would not be appropriate.
Well, because I think in your testimony, and you did make some good points, I'll give you that, you didn't cite the president's stated justification for delaying the employer mandate. He was asked about it at a press conference. He said, you know, in a normal political environment, I would pick up the phone, call the speaker, say, hey, this is a tweak that doesn't go to the essence of the law, and we would delay it for a year. But there's not a normal political environment when it comes to quote-unquote Obamacare is what he said. Now, to me, I think that that's totally outlandish of an explanation. It's even more outlandish because Congress, by the time he made that statement, had already passed a bill to delay the employer mandate precisely for the reason that the president suggests. Let me ask you one more question because, Professor Turley, I really appreciate your written testimony, and you cite a lot of examples of the Founding Fathers. And Mr. Lazarus, you've made the point that, hey, the take care clause doesn't mean what the rest of these guys say. Original understanding, founders understood it. But you didn't cite any actual Founding Fathers. So can you cite for me a Federalist paper? Hamilton wrote a number on executive power. Can you cite a constitutional convention debate, a ratifying convention debate, early practice in the Republic that would substantiate your assertion that that is consistent with the original understanding?
Yes.
Jefferson?
There's very.
Madison?
No, there's very little discussion.
Hamilton?
There's very little discussion, but what there is.
Well, right, so then you're making an assertion that's not justified by the historical fact. And I understand the theory that you're positing, but I think it's tough. You've got to back it up. And I think Professor Turley backed up what he was trying to say. And so I'm asking you, who would you point to?
Can I finish?
Well, I want you to answer the question.
The answer to the question is that during the Constitutional Convention, this is what I said in my testimony, and this is what the basis of the interpretation is, and I think it's widely accepted. Originally, what became the Take Care Clause didn't have faithfully and didn't have take care in it. It just said that the president shall carry into execution the laws. As the debate went forward, that got changed, and faithfully and take care were added. And
I understand that.
What I said is that, and there really isn't, and what I said, what that clearly shows, and I think that what scholars on all sides have accepted, that shows that the president is to faithfully, in good faith.
Let me reclaim my time because you have made that point. Secondly, and that wasn't my question. My question is about show me something I can go where Hamilton's saying this or not. You're talking about
this is even more powerful. It doesn't
matter. And I think Mr. Turley's point about the language is more correct. But let me just say one other thing.
This is the actual legislative record, and it is more.
So the text matters there, but it doesn't matter with the ACA because you're saying the purpose is different from what the text actually says. But I do think, though, the idea of when you're talking about Mr. Cannon's argument about, oh, nobody in Congress, they didn't intend for this subsidy to do. The idea that we know what Congress intended on a 2,600-page bill that many members did not read, much less understand. There were members here swearing you could keep your plan, you could keep your doctor, and now we have members of Congress running around saying, oh my gosh, I didn't know you wouldn't be able to keep your plan, your doctor. So the idea you're going to rely on that over the text of the actual statute, to me, I don't think, I'm a textualist, I would do that anyways, but with this health care law, I think of any law, surely you cannot point to what Congress intended into these intricate provisions, because many of them did not read or understand it.
But it's Mr. Cannon who is claiming that it was the intention. It was intentional and purposeful of Congress to construe the law in the cramped way in which he does.
I thank the gentleman from Florida. The chair will now recognize the gentleman from Texas, Mr. Gohmert.
Thank you, Mr. Chairman, and I thank all of our witnesses. It's good to see some of you back. I don't remember seeing all of you, so otherwise it would be all of you. But if you would suppose with me that you are in a town hall back in a congressional district, and you had an elementary school student stand up and ask this question. I would like to know how each of you would answer this child's question. What right does the House of Representatives have to pick and choose what part of government gets funding? What's your response? Start with Professor Turley.
I'm sorry, the last part of the question.
What right does the House of Representatives have to pick and choose what part of government gets funded?
Well, I think the answer is clear, that in this sort of orbital hole that these three branches are placed by the framers, the key power given to Congress and the House of Representatives was the power of the purse to control the funds. What is alarming about this situation is that even that power is being challenged and being marginalized.
Okay. Professor Rosenkranz.
Article 1, Section 8 gives you the power to decide what provisions, what you want to fund and what you don't want to fund.
And Professor Cannon, Lazarus.
Professor Rosenkranz took the words right out of my mouth.
Article 1, Section 8. Is that okay?
Article 1, Section 8, along with the Senate.
Okay. And Mr. Chairman, I would ask that we provide a copy of the answer to this question to Senate Leader Reid, since he asked that question. Now, with regard to Libya, the President said he didn't need to come to Congress in order to get our authority to start bombing in Libya. And that was a concern to some of us. He said, he'd been asked by the Organization of Islamic Conference, all 50 or 57 states, whatever they got, 50, 57, and also by some of the NATO allies that use Libyan oil. So he didn't need Congress approval because he had those requests. He was initially prepared to help the Syrian rebels, in which al-Qaeda had become, not initially, but they had become the most profound part. And he was ready to start bombing the Syrian leader that Hillary Clinton had called a reformer. Initially, he planned to do that without Congress's consent. He didn't think he needed Congress's consent, but obviously once there was a lot of political pushback, he threw it to Congress and let them decide. But I'm curious from each of you, what gives the President the authority to order bombing, even if he promises to limit the numbers of people that he will kill? What gives him authority to go start bombing a country? Obviously, we'd consider it an act of war if any country started dropping bombs over us. Well, what gives him that authority? I'm curious from each of you.
Well, first of all, I think it's a great question, because I was a little confused when Mr. Lazarus says no one's accused President Obama of being inclined to engage in war without a declaration. I was in court with members of this committee saying exactly that in the Libyan war conflict. And what disturbed us is that the White House came back and said the reason we don't need a declaration of war is because the president alone defines what a war is, and he's simply saying this isn't a war. And when we talk about the dangers, this is a danger of a different kind. And it not only is a danger of separation of powers, obviously, and a direct violation of the express language of the Constitution, but this administration, through these acts and through the large number of drone attacks, is returning the world to a state of nature. We are taking down critical international legal principles that have governed this world, that have respected territorial limitations. I just spoke to the NATO parliamentarians, and I told them, you will loathe the day that you endorse the U.S. position that they can take unilateral action when somebody vaporizes someone in the middle of London.
Well, my time is about to run out, so let me morph that into this question to each of you, get your answer. You know, the president ordered Anwar al-Awlaki killed by a drone strike in Yemen, an American citizen without any due process, as we've come to know it. I asked the question in this room at another hearing, you know, how far does that order extend? I mean, if al-Awlaki came back to Capitol Hill and led prayers as he had before of congressional staffers, was that order still good? I wanted to know in case the drone strike was still on. What authority do you think the president has to order American citizens killed in other countries in which we're not at war or in the U.S.? So if y'all, my time's up, but if I could get answers to that question from each of you.
As quickly as you can, given the subject matter.
I don't believe he has authority to do that. They've cited things like hot pursuit, which makes no sense. It's not an imminent threat. I believe the president's kill list policy is flagrantly and dangerously unconstitutional.
I think it's quite a difficult question, but the Obama administration's Office of Legal Counsel memo on this is certainly quite strained. So they are reaching for analogies and analysis that is quite unconvincing, I'd say.
Professor Lazarus.
I am very, very far from an expert on these matters, but I would just offer one observation, and that is I don't really see why the American citizenship issue in the case that the Congressman is referring to is all that significant. I think that if a Nazi general happened to have been an American citizen, it wouldn't alter the way we could deal with it militarily. But there are weighty questions about the president's authority to implement the drone program. I don't really have an expert view on that.
Briefly, Mr.
I think it's been very effective militarily, so that is a good thing.
I'll just associate myself with Professor Turley's comments.
Okay, thank you very much. Appreciate y'all's testimony.
Thank the gentleman from Texas. The chair will now recognize another gentleman from Texas, Mr. Farenthold.
Thank you very much, Mr. Chairman, and I appreciate the opportunity to ask some questions here. And I'm going to ask for y'all's help in answering what's probably the #1 question I get at town hall meetings and people running up to me at the grocery store when I'm back home in Texas. And it goes something like this. And in light of, and you can insert whatever you want, Benghazi, Fast and Furious, the IRS targeting of advocacy groups, NSA overreach. If you like your health care, you can keep it. Varying the terms and waivers of Obamacare. The #1 question I get is, what can you do about it? We sent you, Congress, to do something about this. And I've listened today, and I've heard, well, we can enact new laws. Well, that doesn't work if they can't get through the Senate and the President himself won't sign them. We can use the power of the purse. Well, that's pretty much dead. We've heard testimony about that. And in the era of continuing resolutions, we don't have a lot of options there. Well, we could go to the court. We've heard about the standing issue. We've also, even when there is standing, a delay tactic leaves you, probably the president will be termed out by the time any of these court decisions are held. We talked a little bit about elections. I think Chairman Issa brought up the issue, with the IRS scandal really interfering with elections, that's kind of off the table. And I'll admit my party didn't do as well as we probably should have in the other election, but we did do well in the 2010 election when historic numbers Congress changed. And then we've also talked about the I word, impeachment, which again I don't think would get past the Senate in the current climate. Am I missing anything? Is there anything else we can do, Mr. Turley?
Well, it does paint a dire picture. As we've said before, for years I've encouraged members to consider member standing as a standalone issue of trying to find a way to establish it either constitutionally or through statute to allow members of Congress to have...
Okay, so there's one fix to the court system, but you're still not going to get that through in any amount of time.
Yeah, to me the most troubling thing is I just published a law review article on recess appointments, which I also testified on. And
we forgot that one in the list of...
Well, what's fascinating about it is that because Congress has been stripped of more and more of its power, it has actually put more emphasis on appointments as a way of controlling the White House.
Have we been stripped of it, or have we inadvertently given it up?
I'm afraid it's either by a claim or it has been a...
I want to get to the rest of the panel. Mr. Rosencrantz?
Well, I've said it before. I'm sorry to say that the ultimate remedy for this sort of thing is elections. And, democracy is slow and messy, but at the end of the day, the right answer for this committee is to hold hearings like this, to publicize what it takes to be violations of the Constitution, and for that to become an election issue.
Mr. Lazarus, I realize you don't think we have the problem with the president a lot of my constituents have, but have I missed anything on a remedies against any rogue, and I use the term in broad general, not pointing to anybody in particular, a rogue president?
Well, I think that is, with all due respect, a gross misrepresentation of this president. And
I wasn't pointing to this president, a hypothetical rogue president.
Well, we know. We had a rogue president who was driven from office and who would have been impeached and convicted had that not happened. And actually, that result was guaranteed in this very room when the ranking Republican member of the Judiciary Committee voted to impeach Nixon. So, sure.
Mr. Cannon.
Well, I think what Professors Turley and Rosencrantz said is accurate, or would help member standing. Yes, you have to win elections. Something that hasn't been mentioned is getting Democrats to care about this issue when there's a Democratic president, and getting Republicans to care about these issues when there's a Republican president.
And that's one of the things.
Right now, I don't know if anyone who's watching this at home has noticed, but all the Democratic members of the committee have left the room. I think they left like 20 minutes. We're 3.5 hours into this hearing. They're obviously not as interested in this as
And finally, I think one of our problems here is we have a president right now who is not willing to work with Congress. I think that's what we just had a Democrat walk in. That's not willing to work with Congress.
I retract my statement. My apologies.
I've talked to a constituent who worked for the Bush White House, whose job it was to lobby with Congress. And I've met with somebody from the Obama administration exactly twice in 3 years. And I do think it's the president's duty to engage. I had a question on that, but I'm out of time. But I do think there is a disappointment with the president not being engaged. Mr. Cannon.
But if I may, Republicans are very concerned about executive power when the executive is a Democrat. Democrats are very concerned about executive power abuses when the executive is a Republican. I think that the members of each party need to care about these issues a lot more when their own if someone from their own party occupies the White House, and not just when someone from the opposite party.
Thank you. I see my time has expired. Chairman Gowdy, I'll give it back to you.
Thank the gentleman from Texas. Chair would now recognize the gentleman from Tennessee, Mr. Cohen.
Thank you, sir. I have obviously missed some of this hearing, although I've caught some of it on the magic of video, television. And I was interested, the gentleman from Mr. Cannon had mentioned the possibility of impeachment or some impeachable offenses. Is that accurate?
I can't remember if I brought that up. I may have.
And in what context would you have brought that up?
I think in response to a question. I'm not sure if I did or if someone else had mentioned.
Can anybody on the panel refresh his memory?
I think what I brought up was a constitutional amendment convention. I'm not sure. I don't think I brought up impeachment, but it's certainly that I agree that it's certainly a tool that the Congress can use to restrain the executive.
Constitutional amendment, you suggested we should have some type of convention?
The question I was asked was, I was asked about ways of the Congress or the people can restrain the executive, and I offered that as one way.
That's never been done before, has it?
Not that I'm aware of, no.
Yeah. Anybody else on the panel have any thoughts about impeachment?
I mentioned impeachment earlier. We've been asked several times questions about possible remedies if we find that a president is behaving lawlessly. I've not said that this president has or that these examples rise to that level, but the ultimate constitutional check on a lawless president is impeachment and ultimately election.
Right, that's the check. But nobody's suggested that there's the president certainly not committed any impeachable offenses, I presume. Is that nobody here thinks that? Is that right? Mootness? You, Mr. Cannon?
Well, I don't know. As Professor Rosenkranz mentioned, I think an important element is that that whatever crimes or misdemeanors he's committed were committed knowingly, and whether there is a pattern of abuse of his office. And in my testimony, you'll see that I actually lay out a pretty consistent pattern whereby the President Obama has ignored and tried to rewrite portions of the Patient Protection and Affordable Care Act. And I think that the most egregious of these is the one where he is implementing the law in a way such that he is taxing and borrowing and spending over the next 10 years. $700 billion that this Congress never authorized. Now, you may disagree with my interpretation of the law. I know Mr. Lazarus does, but I think that you and I and Mr. Lazarus would all agree that if a president were trying to tax and borrow and spend $700 billion without congressional authorization, that might be an impeachable offense.
Does anybody here think any of the actions of the Bush administration and going into Iraq without actual knowledge of weapons of mass destruction or anything else would have been a impeachable offense? Mr. Lazarus, you seem to be nodding.
No, I was just disregard the nod behind the curtain or in front of the curtain. I was very upset by that, but whether it's impeachable is a political decision that Congress would have to make.
Mr. Turley?
Well, the war powers issue does come closest for me for both President Obama and President Bush. The reason I don't think it rises to that level is because court decisions have made this field so much of a mess. First of all, by judicial passivity in not reviewing it, and by the use of historical practice. So I think it's very hard to maintain an impeachable offense when you have that degree of ambiguity. I don't believe that ambiguity is found in the Constitution. I believe that President Obama violated the Constitution in Libya, for example. But because of that history and that precedent, they can claim that they were acting on a reasonable interpretation of the law.
Thank you. Mr. Gowdy, I congratulate you, I guess, on South Carolina's victory, and I yield back the balance of my time.
Thank you, Mr. Cohen. I got to be careful how I respond to that since they're both state schools. I thank the gentleman from Tennessee, and we now recognize another gentleman from Texas, former Judge Poe.
Thank the chairman. I disagree with you, Mr. Cannon, on that Republicans are only concerned about executive abuses when Democrats are in control. I personally don't like any executive abuses, no matter who the president is. And I think our executives have gotten out of control over the last several executives, not to mention the judicial branch, which I served in for 22 years. I think it has exceeded its boundaries of the Constitution. But we're talking about the executive branch. In the Constitution, if I remember it correctly, the executive branch is mentioned second. The first one mentioned in the Constitution is the legislative branch. That would be Congress. Third is the judicial branch. My understanding of the writers of the Constitution, they put the most important one first and the least important last, because we're elected and the guys on the other end are appointed forever. In the middle is the executive branch. The President has said we are not a banana republic. there's a lot of definitions to banana republic, but my view of a banana republic is a lawless country. We are proud of the fact in the United States we are a country of laws, not people. But yet we are in a situation where the law means different things to different people, and it isn't enforced. And like many have said here, back home in Texas, they just don't understand where the president gets the authority to do some of these things without congressional intervention. I agree with the people that I represent. And they're from both parties. They're not just Republicans. They're saying, well, how can he do that? If I hear that once, I hear it 100 times when I go home on weekends. How can he do that? And what are you going to do about it, Congressman Poe? I get asked that a lot. We've had some discussion about those things. We know the subjects. There are a lot of subjects where people question whether the president has authority. But let's spend one moment on one issue. Obamacare, according to the Supreme Court, is a tax. The president has used the law and has said that I'm going to postpone that tax for this group first, big business. Then I'm going to postpone the tax for 6 weeks for individuals. And then I'm going to postpone the tax a year for small businesses. He's postponing taxes. Since I have no life, I have read Obamacare. I don't see that in there where the president, we gave him the authority to postpone a tax, but he does it. Now, if he has the legal authority to do that, which I doubt, but he used that authority, what is to prevent him from just going and looking at the IRS code, which is a mess? I don't know any American that thinks the IRS code is a good bill, but rather than fix it, we just make it bigger every year. So the president goes to the IRS code and says, well, this group of businesses, they're just having a bad year, like green businesses. Or we could use the energy companies on the other end, those oil and gas industry. I'm just going to postpone them paying income tax for a year. Why? Because I said so. Or I'll take this group and do something similar, tweak their tax. Rather than paying 38%, they're going to just pay 20% for the next year. It seems to me if he has the legal authority to amend taxes, which the Affordable Health Care Act is a tax according to the Supreme Court, what is to prevent him from just amending any tax to his liking? Mr. Turley, weigh in on this, if you would, Professor.
Thank you, Congressman. I have to agree. First of all, on your first remark about Article 1, as I've said before, it is true that they're all equal branches, but the framers spent the most time on Congress because it is this thumping heart of the Madisonian system. It's where the magic happens, and that magic is to take those factional interests, those interests that destroy countries, and turn them into majoritarian compromise. And when we get to the issue of taxes, as you've raised, that's one of the most divisive issues facing a country. And so when someone comes before Congress and says, I want my group to be excluded, it obviously produces a great deal of heat from people saying, well, how about my group? How long should this apply? It is perhaps the most divisive issue that is raised in Congress. And that's precisely why it was given to Congress, so that those types of issues would be subject to this transformative process of legislation.
So do you believe that that would be an unlawful constitutional act if the president started amending the tax code on his whim?
Yes, I do.
Let me ask you one other question, if I may, Mr. Chairman. You've mentioned remedies. What about the remedy of a mandamus? Would a mandamus remedy lie in any situation where Congress thought the executive had not enforced the law?
Mandamus can be very difficult in some of these if you're trying to use mandamus against the president, but you can challenge some of these decisions. For example, the HHS decisions is violating APA, for example. You can go with if you have standing to do so. Those are obviously a long process. And this is one of the things where I tend to get off the train with at least one of my colleagues. This is not an APA issue. This is a constitutional issue. It's a president usurping the authority of Congress. And to say that this is just something that we leave to agencies, I think radically misunderstands the severity of the situation.
Thank you, Mr. Chairman. I yield back.
I want to thank all of our witnesses for an excellent hearing, a great discussion on what I think is one of the most important issues facing our country today. I want to also thank the members for a very strong participation in today's hearing, and that means the witnesses had to stay maybe a little longer than they had originally thought they would, but that only means that you've had the opportunity to talk through and think through and debate this issue even more extensively. So I thank all of you for your participation.